Hey everyone, today I'm going to talk about non-disclosure agreements. Non-disclosure agreements are contracts between two or more parties that outline the handling of confidential information that the parties wish to share with one another for a certain purpose, but wish to restrict access, do not want to prevent leakage of the confidential information. Examples of when non-disclosure agreements, NDAs, are used would be joint ventures before parties enter into joint venture, or collaborations, or sale of businesses before the seller sells his business. He would want the buyer to sign an NDA because the buyer will want to look at the confidential information about the company before buying the company. So, I'm going to discuss the common clauses in NDAs. The first one that is very important, you need to state the purpose for sharing the confidential information. The clause will usually state the purpose for exploring a joint venture and for no other purpose. That means the confidential information cannot be used for any other purpose. Another thing that is important to include would be that the recipient, the person receiving the confidential information, has to keep the confidential information secret. That it will be kept secure and in strict confidence and not directly or indirectly disclose, copy, duplicate, reproduce, distribute, disseminate, or supply the confidential information to anyone. It is also common to state the level of care that the recipient should treat the confidential information. Usually it goes along the lines that the recipient has to treat the confidential information with the same security measures and degree of care as it would treat its own confidential information. Another important clause would be that the disclosure of the confidential information will not confer, will not give any rights at all whatsoever, including intellectual property rights in respect of the confidential information. So just because the recipient gets the confidential information doesn't mean he has the right to any of the information inside. It is also important to include a clause that the disclosing party makes no warranty or representation as to the accuracy or completeness of any of the confidential information, to protect himself for getting sued for providing inaccurate confidential information. It is also important to state that the recipient should immediately inform the disclosing party of any unauthorized use or disclosure, misappropriation, that means stealing, or misuse by any person of the confidential information. There should also be a clause on representatives, that the receiving party, the recipient, will provide its representatives, that means its employees, its legal advisors, with a copy of this NDA, and ensure that its representatives understand and will observe all the terms of this NDA. It is also important to include a clause on the return of the confidential information, that when the transaction ends or if the transaction is aborted, all confidential information will be returned to the disclosing party or destroyed. And it is also common to include a clause that in the event the transaction is aborted, the receiving party will have to issue a certificate confirming that all confidential information has been destroyed. It is also important to include an indemnity clause for breach of the NDA. Indemnity clauses simply means if there's any breach, the receiving party has to compensate the disclosing party for loss. You can watch one of my other videos on indemnity clauses. Another common clause you will see in NDAs is that the disclosing party is entitled to injunctive or other equitable relief But I think this is completely unnecessary because it's your right, just like your right to sue. If you suffer any loss, you are entitled to an injunction. So there's really no need to state the obvious. So that's all I have to say about NDAs, non-disclosure agreements. Thanks for watching this video.